specializing in a range of legal services, including family law, matrimonial law, immigration, dispute resolution, Ghanaian customary and family law. At BWF, our solicitors are pleased to offer high-quality legal representation at competitive rates. Our senior partner, Bernard Owusu, has over 29 years' experience as a lawyer in the UK. BWF solicitors provide independent and practical legal assistance for all kinds of family matters, such as childcare, contested and uncontested divorce, and injunctions for domestic violence. Our childcare and family team appreciate the issues facing you in this difficult time, which is why we offer confidential advice delivered in a sensitive manner. Our senior partner is an accredited member of the Law Society Family Law Accreditation Panel, which guarantees expert representation in all family and matrimonial cases. Are you seeking advice on immigration-related matters? At BWF Solicitors, our immigration team are experts in dealing with everything from general immigration to complex immigration work permits, arranging student visas, as well as entry clearance visas, family visas, and appeals. Our senior partner is an accredited member of the Law Society Immigration Accreditation Panel, which guarantees expert representation. Our office is open from 9:30 a.m. to 6 p.m. Monday to Friday, and on Saturdays by appointment only from 10 a.m. to 4 p.m. We are located at 4th floor Anna House, 214 to 218 Tottenham High Road, London, N15 4NP, just a short walk from Seven Sisters Underground. Our senior partner, Bernard Owusu, is also a qualified barrister and a member of the Ghana Bar Association. He has acted as an expert in court cases involving aspects of Ghanaian law. He has also advised local authorities, the official solicitor's office, and other solicitors on the intricacies of Ghanaian law, and is a regular contributor on the radio and TV on matters concerning Ghanaian law.
Hello. Good afternoon, good morning, good evening to you watching anywhere in the world. You are welcome once again to hanging out with BWF solicitors. Today is the 28th of January. Wow, we thought January will never end. We are almost there. I hope you had a lovely week. We've come your way today with another interesting topic. This is Hanging Out with BWF Solicitors, and I'm your host, Vicky Newton. Just tell you a little bit about BWF. As you know, BWF is a law firm. Some of their specialities is family law, immigration and nationality, Ghana law and practice, dispute resolution, just to mention a few. And BWF solicitors have won so many awards. One of the awards is, them winning one of the top three. They are one of the top three family law solicitors in London. Today's topic is what legislation gives EU nationals and their family members the right to receive public funds. The topic again is what legislation gives EU nationals and their family members the right to receive public funds. We are live on Facebook, YouTube, and all social media handles. If you'd like to contribute to this program, you can do so on all our Facebook, platforms and YouTube at BWF Solicitors or Vicky Newton. When you send in your questions, my learned solicitor and partner of BWF Solicitors, who is in the person of lawyer Eunice, will answer all your questions. You can also send me a WhatsApp you know, message, and I'll be able to read it for Lawyer Eunice to answer all your questions. If you prefer to call me directly, of course, you can do so on 0744 8619 711. The number again is 0744 8619 711. Please, please, please do me a favor by sharing this program to all your contacts, colleagues, friends, and family. Every time we have this show, I get people telling me, giving me feedback. Vicky, when I shared this program with, friends on a platform, the feedback was amazing. They realized that there is hope, something can be done about their cases. Everybody is different. And, this is what we want, for people to know what the law says and how to go about, regularizing their stay in the country. So please, please, please share and be a blessing on, on someone. Let me quickly get to my guest. Laura Eunice, you're welcome to today's program.
Thank you so much. How have you been?
Yes, I'm doing very well. Looking forward to today's program.
Of course,
Yeah,
the first one for the year.
the year of the year. And
Yeah.
when I was giving my intro, I mentioned that I thought January was never going to end. It's been it's the
To tell
longest.
you the truth, I feel like it has come quickly. I don't know. For me,
Is
that's what
it?
I feel. Yeah,
Is it
because
because
I
you've
don't
been
know.
very busy with case work?
Yes, I guess it's
It
because
means the
I'm
time
busy.
flies.
Yeah, yeah. I guess so because
Right,
obviously
right.
once the
Mm,
year comes and it starts off quickly, you're thinking to yourself, very
mm.
soon we'll be in the middle of the year and then it will be Christmas again. So
Yes,
it's good. At least the weather hasn't been too bad this
too
week as
bad.
well.
Yeah,
Yeah. So it's
yeah.
it's, it's all good.
Right,
Yes.
right. Right, Eunice, as usual, people will be wondering, oh, what has been going on in the past week? Has there been any changes? Definitely, things changes all the time when it
Yeah.
comes to to the home office. And every time we come on this program, you make sure to keep us abreast with what is going on,
Yeah.
the current changes. So without wasting my time, we very much appreciate it if you give us. And for some reason, every time you have, an update,
Yes.
there
Because
hasn't been any one time that Laura Eunice will tell me that, Vicky, let's go straight to the topic. There seems to be no update. Let's go straight to the topic. But every time we come on this
yes.
program, you're able to give us updates.
Because there's always something that is being changed or being brought to our attention for us to be made aware of and all of that. So, yes, as we have entered into a new year, I would like to wish all of our viewers a happy new year. I hope the year has started off on a good foot. And even if it hasn't, we thank God that you are still healthy and you are still alive. So it's a good thing that you are here with us and you are participating with us. So,
Yes.
yes, as this is the first program for the year, today is my grandmother's birthday, and I wish her a
Oh,
happy birthday. I know
wow.
my grandmother is still alive. I wish her a happy
Yes.
birthday, and
Mm.
I wish her good health. And I pray that the Lord will continue to watch over her even in her old age. So, yes, happy birthday to Alice Nakwale Akumi. Yes.
Wow. Wow. Happy
Yes.
birthday, Grandma.
So, yes, in regards to our updates, when it comes to the biometric cards, a lot of people are still asking, why is it that when I receive my biometric card, it's not giving me the expiry date that I was granted? So, for most people, they receive a letter to say that you have been granted leave from this date to that date. And then when they receive their biometric card states that it is expiring in December 2024, which is next year. Still asking, why is my biometric card stating that it is going to expire in December 2024 when my leave is longer than that? And
Yes.
that is because the UK government have said that they will be phasing out the biometric cards. So they are making everything, should I say, electronic. Everything should be digitized. So your leave will be digitized. The same way when you have your leave being considered again, because maybe you've had your first leave and then you are going to renew. You
Okay.
ask your employer to go on the employer check-in service to check if you have the right to work. That is a digital form of checking your leave. And so they want to make everything digitized so that at any point in time, they can just go onto their system. So if you were to travel, for instance, and then you said to yourself, I am traveling, and therefore, when I'm coming back, if I don't have a card that is valid, so let's say you're coming back in January 2025 and the card is has expired, they will see on their system that you have a leave which is longer than their system. So that is the reason why most biometric cards have the date December 2024. So that's the
Okay.
first one.
Right.
And then in terms of the usual, I think updates in regards to applications, and I know that people also want to know how long the processing time is as well. So when it comes to the processing times, usually we would have said that applications in the UK would have taken a period of 6 months, but it's taking longer than that for further leave to remain applications based on family. If you're making a skilled worker or a student application is supposed to take roughly about 8 weeks to make a decision. Sometimes it takes even longer than that to come up with a decision. And then if you're making applications from outside the UK, it's usually supposed to take 12 weeks and they've asked for 6 months and sometimes even longer than the 6 months. So
Oh,
the processing times have changed. But the good thing is that they have said that there are priority service available for those that are applying under the family route. And so, if for any reason you feel that you cannot wait that long, please, you should then have funds available to also book for priority. And any fee, of course, will be fee in addition to the application fee. So if the application fee is 2,600 and then you are paying for the priority service, it will be an additional £800 on top of that. Those that are outside the UK, if for one reason or the other you book for the application, then it means that the application that you have will be the application fees in addition to any priority service, which is an extra £500.
okay.
So you have to consider the cost involved when you are making such applications.
Patience.
And there are those who, for one reason or the other, have complained that their applications are taking long and they will want to switch to a priority service. When that happens, what happens is that the caseworker working on the case would usually send an email to say that if you have applied for your wife or your husband to join you in the UK, we will then send you a link for you to be able to switch to the priority service. So you will be paying for the priority service fee. And that will take another 15 working days for them to make a decision on that person's application. So that's a good thing in terms of people who've already applied for out of country applications, such as applying for your husband or your wife or your child to join you here in the UK. So that's also another thing. And then
Oh,
moving on to the third one, I don't want to stay too long on updates. Uh, Moving on to the third one, when it comes to those of us who are keen on letting our, should I say, family members and friends come to the UK, And especially when it comes to those who want to apply to the skilled worker route, I know that the care work route is very much in demand. So what happens is that because a lot of people know that the care worker route is the one that most people can apply to, they usually say then apply to that one. But then we also have the teachers as well. So if you know that you have a trained teacher back home who would want to come and teach here in the UK, there are opportunities under our skilled worker appendix where people can also apply to come and teach in the UK. So, in that case, obviously, they would be applying as a skilled worker. They should be able to meet the required skill level. So, they are teachers, and so I'm sure they would have gotten some form of qualification to teach,
Okay.
and then they should be able to show that they have applied for a job in the UK. They have received a certificate of sponsorship, which allows them to apply to the UK to come to teach here in the UK. And then they have to show that they have met the English language requirement. So that means that they should be able to show that they either have an undergraduate degree or they've taken the English speaking and listening and writing and reading exam. So it's called the IELTS. And so once they have taken the IELTS at a level B1 or B2, they should be able to then go ahead and say that they can make the application. And
Right.
usually, as long as the salary that they are being offered is at the job market level, they should be able to make the application to come to the UK. So yes, that is also another thing to look forward to in the coming, in the coming months. And then last but not least, in terms of those of us who have family members that are EU nationals and are in the UK, very often I hear that I've lived in the UK for such a long time. I never knew that I was supposed to apply to this EU settlement scheme. And maybe it could be that maybe that person's employer hasn't really been made conversant with the new rules, or it could be that the person is self-employed, so they haven't really come into that place where they are supposed to show or share the code, because a lot of EU nationals and their family members know that they are supposed to share their code when it comes to renting a place or working with an employer. But
Yeah.
if the person is self-employed or maybe the person owns their own home, they haven't got a clue about all of the things that are going on. Or even if they do, they think that maybe it's applicable to the ones that are now coming. And so it doesn't apply to them. But we have to make sure that we also educate those EU nationals and their family members who have been here for years. It is not only for those people who came, let's say in 2019, or those people who came just before Brexit took place in January 2020. So if you have any family members who are EU nationals or they are family members of EU nationals, please let them know that they are to apply to the EU settlement scheme, as the UK government is now said that that is the only way that they can regularize their stay. So if they have any other leave, which is the residence card or permanent residence, that no longer applies. They have to have the pre-settled or the settled status under the EU settlement scheme to be able to be seen as people who have immigration status in the UK. Otherwise, there are a lot of things that you would not be able to, should I say, receive as a legal citizen if you are not on that scheme. So it's best that you apply to the EU settlement scheme and that you are granted leave to remain or limited leave to remain or settled status, so that you can also be seen to be somebody who is also legal in the UK. So that is to round us off with our updates.
Thank you so much, Laura Eunice. Ladies and gentlemen, if you've just joined us, this is Hanging Out with BEWF Solicitors, your free consultation program. You will not be charged, for asking your questions, getting an insight into what your issue is, and also a platform for you to get free legal advice. Today's topic is what legislation gives EU nationals and their family members the right to receive public funds. With me is lawyer Eunice Achampong. She is also a solicitor and a partner of BWF Solicitors. She was taking us through some of the updates, during the week in regards to, the Home Office. If you want to contribute to this program, we would love to hear from you. You can do so on all our social media handles, especially Facebook and YouTube at BWF Solicitors or Vicky Newton. If you want to send me a WhatsApp message, of course, you can do so on 0744 8619 711. 0744 8619 711. You can also give me a call and speak to Lawyer Eunice live on the program. Right, Lawyer Eunice, regarding this topic, now one wants to know, how does the recent case of SSWP versus AT, which is the Air Center and IMA intervening 2022, UKUT 330 AAC, determine whether EU nationals and their family can receive universal credit.
Sorry, I think that something has just popped up on my screen. I just wanted to go and check it out for a minute, and then we can come back.
Okay, so can we please play, an ad quickly?
Yes, please.
Yeah.
Thank you.
All right.
Based in London, we are a dynamic award-winning firm specializing in a range of legal services, including family law, matrimonial law, immigration, dispute resolution, Ghanaian customary and family law. At BWF, our solicitors are pleased to offer high-quality legal representation at competitive rates. Our senior partner, Bernard Owusu, has over 29 years' experience as a lawyer in the UK. BWF solicitors provide independent and practical legal assistance for all kinds of family matters, such as childcare, contested and uncontested divorce, and injunctions for domestic violence. Our childcare and family team appreciate the issues facing you in this difficult time, which is why we offer confidential advice delivered in a sensitive manner. Our senior partner is an accredited member of the Law Society Family Law Accreditation Panel, which guarantees expert representation in all family and matrimonial cases. Are you seeking advice on immigration-related matters? At BWF Solicitors, our immigration team are experts in dealing with everything from general immigration to complex immigration work permits, arranging student visas, as well as entry clearance visas, family visas, and appeals. Our senior partner is an accredited member of the Law Society Immigration Accreditation Panel, which guarantees expert representation. Our office is open from 9:30 a.m. to 6 p.m. Monday to Friday, and on Saturdays by appointment only from 10 a.m. to 4 p.m. We are located at 4th floor Anna House, 214 to 218 Tottenham High Road, London, N15 4NP, just a short walk from Seven Sisters Underground. Our senior partner, Bernard Owusu, is also a qualified barrister and a member of the Ghana Bar Association. He has acted as an expert in court cases involving aspects of Ghanaian law. He has also advised local authorities, the official solicitor's office, and other solicitors on the intricacies of Ghanaian law, and is a regular contributor on the radio and TV on matters concerning Ghanaian law.
Welcome back, ladies and gentlemen. Yes, Lawyer Eunice.
Yes. So you were asking in regards to the case law,
Yes,
which was decided in 2022, which was
2022.
very late last year. Yeah.
Mm.
Yes. In regards to that case, let me just give a brief background as to what that case was about and how it affects people now, because very recently, or should I say in the last 2 years, a lot of nationals or their family members will say, "Oh, I've been told I'm not eligible to apply for benefits, and because of that, I just have to make sure that I am able to get some part-time job to be able to take care of the kids and pay for bills and the rest of it." So it's been a bit tough on EU nationals and their family members who have come to live in the UK, especially after Brexit. And so this case is to do with a Romanian national who was living here with her husband. She came back um, in 2018 after a series of abuse from her husband, and she came and she wanted to be able to take care of her child. So when she came back in 2018, she obviously um, had enough of the abuse from her husband
Abuse.
and left the home with her child. So she went into a refugee safe home. And at that point, she was able to access child benefits. So she was trying to manage with the child benefits that she was being given. Unfortunately, that was not going to be enough for the both of them. And so she applied for uh, universal credit from the Department of Work and Pensions.
Pensions.
Her application for benefits was refused. And so she thought to herself, what else could she do? Because there's no way that she could continue living in this refugee safe home and also look after herself. So, yes, you can have a few food vouchers from different companies, but that
Mm.
is only food vouchers. You need other essential things such as clothes and water and the rest of it. So, you can't just rely on the food vouchers. So, they refugee shelter helped her in applying to the first tier tribunal to say that, well, I've been refused universal credit. I tried to appeal to the Department of Work and Pensions to review their decision. It didn't go as I planned, and that's why I'm appealing to you, the first tier tribunal, to be able to have access to universal credit. And so, of course, um, they had to look into the case and see whether she should be eligible to have any form of universal credit. So, universal credit was introduced by the Welfare Reform Act. So, the Welfare Reform Act of 2012 introduced universal credit. So, it put things like child tax credit, housing
Mm.
benefit, the allowance, income support, all of it in one um, thing that they call the universal credit. So that's why it's called universal. So that it's no longer uh, sectioned into different benefits, but
Tax
it'll all come
credits.
under one.
Working tax
And
credits and yeah.
yes, all of that will come under one. So with the Welfare Reform Act of 2012, we had the introduction of the universal credit, which includes a standard allowance that they give. Then they give, if you are in need of housing benefit, they also include that under any benefits to do with being to do with being responsible for children is also under there, and then any other particular needs that claimants may have will all come under universal credit. And so usually to be able to be eligible for universal credit under section 4 of the Welfare Reform Act, they have to consider certain basic conditions and also financial conditions for you to be able to meet the universal credit. And so they definitely need you to need you to be somebody who is under the age of over the age of 18, but also not in education. So if you're in education, that means that they are in a way granting you some form of benefit, because as we all know, education is free in the UK. And then if you are saying that you live in the UK, they need to be able to consider other requirements as well. And that's where you have the universal credit regulations coming in. So with the universal credit regulations, particularly the one from 2013, it introduces the fact that if, for instance, a person is able to show that they meet the basic conditions, one of the things that they look at in determining whether they meet that basic condition to have access to universal credit is the fact that they are habitually resident in the UK. So if that person can show that the UK is their home, and of course, there are certain exceptions to that. So it states clearly that they have to show that they are habitually resident in the UK, and also that they also are not people that come under certain regulations within our former EU regulations 2016. And
Mhm.
so that includes people who have resided here under 5 years. So people who, for instance, may have residence card for 5 years. It includes people who have come for a 3 month period. So their initial uh, residence, which is only for 3 months. And of course, if it includes those people, it will definitely include people under Zambrano as well, because that right is to do with them deriving their right from a British citizen. So, in terms of those that have a residence card who have come here and they've lived here just under 5 years, because they have family members here in the UK that are EU nationals, or they themselves are EU nationals. So if they have just that residence period for less than 5 years, or they've just come into the UK, they've lived here less than 3 months, or it could be that they could be Zambrano carers or dependents of EU national children as well. So all those people would not have the access that they need to be able to say that they are ones that have a right to reside, and therefore they have access to universal credit. So under the regulations, it did not allow such people to, of course, apply for benefits, and even if they did, they would not have access to it.
Oh, okay.
So it was one of the reasons why 80, this Romanian national from this case,
Mhm.
was saying to the court that she needed access, but the law didn't seem to be on her side. So the court looked at the case and then looked at the EU regulations and also looked at certain EU treaties that allowed EU nationals to have their rights here in the UK. And one of them being the Treaty for the functional EU nationals in the country. And so, for instance, if I am an EU national, I'm a French national, and before we had Brexit, I came into the UK and I was working. So you had to be a qualified EU national. So either that you were working, or you were self-employed, or that you were a self-sufficient person with your own comprehensive sickness insurance, and
Mm.
you intended to live here in the UK after 3 months. That in itself was saying to the UK government that you intended to live here. So at the time, you didn't even have to apply for residence card, because the
Mm.
very fact that you were working was a right that you had in itself to reside in the UK. So most EU nationals will come and work, and they would have access to benefits because the treaty rights allow them to be seen just like any British citizen or any citizen who was settled here in the UK. So there was that as well, and then there was the fact that EU nationals also had rights which were enshrined under the Charter of Fundamental Rights. So, part of the fundamental rights as an EU national coming into the UK would have been that they should also have access to social security and certain benefits, just as any other British national or any other settled person here in the UK. So, of course, um, they had to look at all of that, and they had to look at whether this will still be applicable after Brexit, because before Brexit, this was the stance. So after Brexit, does it still apply? And so the court looked at the EU withdrawal agreement that was drawn up in 2018, and they said that because it was something that was stated under Section 5.5 of the withdrawal agreement, that EU nationals and their family members who were in the UK should still have union rights. And so, union rights include treaty laws and the EU Charter and other EU laws that were regulating EU nationals prior to Brexit happening. And so, if it generalizes that they should still have these rights under union law, then
Mhm.
of course, this lady 80 had to have the right to social security just like any other EU national or EU family member who was still residing here in the UK. Of
Mm.
course, the Department for Work and Pensions didn't like that because it would be giving too many people access to benefits. So they appealed to the upper tribunal. The upper tribunal definitely agreed with what the judges in the first tier tribunal had said.
Wow. Okay.
And the Department of Work and Pensions was still not in agreement with that. So they're taking it higher to the Court of Appeal, and that is yet to be decided. So,
Mm.
as it stands, um, it gives the law as it stands, which is the case law, gives EU nationals and their family members who have not yet got settled status, so they have pre-settled status or they have limited leave to remain, to be able to apply and to be able to have access to universal credit because as the law has been interpreted, it means that they should also have the same access as before. So we are waiting to see what the Court of Appeal also says
Says.
in regards to this case. Yes.
Okay. Yeah, Gloria, so with this particular case,
Yeah.
2022, if we have similar, people in this similar situation,
Mm.
does that mean it's not straight cut, but you would have to, you know, appeal in court for
So,
you, for you to be given the permission to
mm,
receive universal credit?
so when
Everybody has to go to court?
so when something like this happens, so what usually happens is that the Department of Work and Pensions obviously is aware that this case is ongoing, and it
Okay.
knows that this is the stance that the first year tribunal and the upper tribunal have. And so if they have decided that they should have access, then it means that what the Department of Work and Pensions will likely do is that they will tell you that we can't make a decision on your application
Right.
during this current period. We are trying to put policies and things in place, and then once we have, we will definitely make a decision on your application. So obviously they will prolong it just because they want
Yeah.
to know what the Court of Appeal will also say in regards
Mm.
to this matter. Um, if you have a family member who is obviously has lived here before the withdrawal agreement was coming into force or before Brexit was happening, they
Mhm.
would definitely still have access to public funds such as universal credit and the
Yeah.
rest.
Mhm.
But for those that happen to be here once Brexit took place, it will be very, very difficult for them to say that they can um, rely on that, because I know for sure that the Department of Work and Pensions will just prolong the application just so that
Okay.
they know what is happening. And it's similar to what happened in regards to the Akisenya case when it came to
Yeah.
Zambrano carers, and
Brano. Yeah.
they had to tell
Mm.
everybody to just hold on, and they won't make any decisions until the decision had been made by the Court of Appeal. So it's likely to be like that as well.
Okay.
Obviously, in AT's case, she had to leave her home, and it wasn't the most pleasant of circumstances. So, considering her circumstance and the fact that she could not work. So there are certain guidelines that the court puts in place as well. You're not just making a decision based on the fact that the law says that she should have access, but you are also
Okay.
saying that she's not able to work. There are no third parties who are able to support her financially. She's not
Okay.
receiving support from the local authority, for instance, and it is unlikely that this person will be able to also work as well. So they call them risk factors,
Risk
because
factors. Okay.
yes, because obviously this person is looking after a child. She is not in good terms with her partner, who is the child's father. There's no way that she can tell the child to go and live with the father when the father is being abusive. So she has to take care of this child. And so,
Mm.
therefore, um, you have to consider everything in the round when making a decision like this. And so, a lot of the time, the court will create some form of idea as to how they would make their decision if you were in a certain situation or in certain particular circumstances. Yeah.
Okay. Okay. All right. I've got Anna asking us, I think you touched on that. She wants to know the criteria. I think she just joined that.
Yes.
What criteria does the court put forward as the basis of receiving universal credit?
So, as I was saying, number
Mm-hmm.
one, they want to know that this person is not able to work. So, at the moment, if the person is unemployed and they, for instance, have full care of the child,
Yeah.
um, that is one factor they will be looking at. They will also have to consider the fact that this person hasn't got support from third parties. So third parties could be family members, could be friends, um,
Okay.
people that are close by. Um, in 80's case, it was a refugee center, and so they probably give her food vouchers, and that was about it. So there was nothing else that this
Okay.
lady was receiving. So they definitely will consider if this person can receive support from third parties as well.
Hmm.
Thirdly, they will want to know if the local authority can provide some support in one way or the other. Some
Yeah.
local authorities, based on Section 17, may offer to give her accommodation and may offer her other provisions in terms of food vouchers and things like that to be able to obviously cater for this child. But as it stands, um, because a lot of local authorities are also under financial pressure,
Financial pressure.
they
Yeah.
always ask what the immigration status of a person is and whether they are eligible to receive public funds before they even go ahead and
Okay.
provide these things, even though by law they are not supposed to be doing that. But it is what it is now. And so, yes, if this local authority or whichever local authority the person is from is not able to provide that support, that also has to be considered by the court. And then they also want to be able to look and see if there are other needs that this person will consider being met by other sources as well. And they look at risk factors. What is the likelihood that this person will will obviously be in a destitute situation if they didn't have access to public funds, or if they didn't have access to universal credit. What will happen to them? Would it mean that this person will be homeless? Would it mean that this person will not have access to going to school, taking this child to school? What would it mean if we didn't allow this person to access
Exactly.
the public funds? So they look at all of these things and the circumstances surrounding the case. So these are some of the factors that the court will look at when deciding whether an EU national or their family member should have access to universal credit. Yeah.
Mm, right, right. Ladies and gentlemen, if you've just joined us, this is Hanging Out with BWF Solicitors. And those who have stayed with us from the beginning of the program, I would also say thank you so much. We really appreciate you. If you've just joined us, the topic is what legislation gives EU nationals and their family members the right to receive public funds. And the lady who just spoke is lawyer Eunice, who is a solicitor and also a partner of BWF Solicitors. She's the one taking us through this topic. If you want to send in your questions, please do so on all our social media handles, especially Facebook and YouTube, at BWF Solicitors and Vicky Newton, two separate Facebook and YouTube accounts. So if you are not able to, get on the Facebook page of BWF Solicitors, you can also check Vicky Newton, same as YouTube as well. If you prefer to send us your questions, you can also do that on WhatsApp on 0744 8619 711. 0744 8619 711. This is a UK number. If you want to call us live in the studio, you can also do so on the same number, 0744 8619 711. Laura Eunice, I've got Cooksey who has sent us, her question. She says, I've been in the UK since 2018. And although I was here for less than 5 years, I was granted benefits for myself and the children. Does it mean that because of this case, we can no longer receive benefits?
So, in regards to Kuku's question, when it comes to those who arrived in the UK before Brexit was taking place, so I said before that we had the withdrawal agreement, which became the Withdrawal Act of 2018. And obviously, within that, it gave certain rights for EU nationals and their family members to be able to still have certain access to certain social securities here in the UK.
Yeah.
So when it comes to those who came, let's say, within the period when we were deciding when Brexit took place, because Brexit took place in January of 2020. And between 2018 and let's say 2020, we were drawing up agreements with the EU. And so if you were somebody who came into the UK at that point and you are receiving benefits, yes, of course, you can continue to receive benefits just because the Department of Work and Pensions is saying that the new regulations does not allow for EU nationals and their family members to receive universal credit if they have pre-settled status or if they have limited leave to remain. Does not mean that automatically your benefits will be stopped, because at the time you were making the application for benefits, you were eligible. And so new regulations will not then prevent you from accessing benefits the way that they should be accessed. And so, yes, you can still continue to receive your benefits. This the regulations were not at the time that you were receiving your benefits, and so it should not affect you in any way whatsoever. Is that okay? Or there's something else? Vicky, can you hear me? I think she's frozen. Okay. Yes, so in regards to Kuku's question, I know that when it comes to a lot of these cases, a lot of people who came to the UK in 2018, and in the case of 80, she came back in 2018 and she was able to, of course, have access to child benefits. But once she applied again to the Department of Work and Pensions for benefits, they said no, she was not eligible. And at the time, because there were new regulations in place in regards to universal credit, which did not allow EU nationals who had lived here for less than 5 years to be able to have access to universal credit. So it made it very, very difficult for EU nationals and their family members to say that they had access to universal credit. And I think that when it comes to cases like this, it depends on how far you can go. And so a lot of people who may be caught up in applying now and not being able to access these universal credits will then have to decide whether they wait for the court to make their decision or whether they continue to um, work and find other means of obviously meeting their basic needs without having to stress too much. And it's always going to be difficult when you have children to be able to balance working and then also getting enough money to be able to cater for all your needs. Yeah.
Okay. All right. I've got another question. I think this person has asked me not to mention her name. She says, "Good afternoon, Lawyer Eunice. I have 3 children between the ages of 15 to 8 years old. We arrived in the UK from Spain in August 2019, and my husband came about a year before we did. My husband and children are Spanish nationals, and I'm a Ghanaian national. In 2020, I applied for benefits as a stay-at-home mother, and because the children were so young, my application was refused. I applied for pre-settled status under the EU settlement scheme and was recently granted limited leave to remain together with the children. My husband and I are struggling to make ends meet. Can I apply again for benefits?" Eunice.
Okay, so this is somebody who is very similar in 80's case, but obviously in 80's case, she was Romanian. So
Yeah.
with her, she was her nationality was an EU country national, and therefore she wanted to know if she could receive universal credit. In this person's case, obviously you said that she's a Ghanaian national, and then her children and her husband are Spanish
Spanish
national.
national there.
So the case, obviously, in 80's case, there was no partner because she had to leave home. But in this person's case, she has a partner who is working. And obviously, she's saying that it's very difficult to make ends meet. So, if that is the case, she would still need access to universal credit depending on what the needs are. So, if the husband is working and maybe there's just enough to pay for the rent and then do a bit of shopping, that means that maybe certain needs will not be met. I don't know whether um, bills are being paid, and children's uniforms and clothing and the rest of it is also being looked after. But whatever the case is probably because the children are so young, and that is why she's not able to go to work at this point in time. And that's fair enough, because when it comes to caring for our children, we all know that they can be a lot of responsibility, especially as they are growing up as well. So yes, in her situation, she can try and apply for the universal credit again, but it is to say that she has to be able to meet the criteria that the court was also put in place. So in her situation, they will need to find out why she's not able to work. If she's not able to work because the children are so young, or she hasn't got childminder to be able to care for them and the rest of it, she needs to also make that known. They will
Mm.
want to know whether she's able to access any support from the local authority. So is the local authority willing to give them any form of housing benefit? If they are, then obviously they know that that in a way is taking care of itself, because the local authority is helping in terms of housing and the rest of it. They are also going to be looking to see, is there any third party support from any person, any family member, any friend. They would
Mm.
want to know whether that support is available to the family. And then, like I said, the risk factors, like if we don't give this person access to universal credit, what is the likelihood that obviously they will not be able to meet their essential needs? They need to look at all of that. And so reasons need to be provided. And so in her case, if she's able to give them good enough reasons based on these four criteria points I've mentioned, then yes, she can go ahead and make another application for universal credit. As I was saying before, if the likelihood of all these four things happening is very great, they may look into granting her universal credit at this point in time. But
Mm.
if it is the case that they don't think that she meets all of the criteria as put forward, they may say that they will wait for the Court of Appeal to make their decision. And then once they have made their decision, they will make a decision on her case. Because let's remember that once the Court of Appeal makes a decision, it will be applicable to all EU nationals
Yes,
and their family members.
it's true.
So then they can't limit it in any way whatsoever. So yes,
No.
that's also another thing that obviously needs
Okay.
to be considered and all of that.
Right.
Yes.
Right. Okay. Wow, we've got 1 minute to go. So in the absence of any more questions, I'll quickly ask you to just summarize what we've discussed so far, and
Yes.
also leave your details for anyone who is watching us and would like to contact you in regards to their case.
Yes, so we've been discussing investor credit, but as a firm, we don't just deal with social issues, but we also, as you said, look at immigration law, and we also look at nationality as well. We deal with entry clearance applications. We also deal with family law in regards to people that would want help in terms of divorce, those that are also seeking contact with their children. So we have child arrangement orders that we can help or assist anybody in making application for, to obviously look at ways they can have access to their children. And then we also deal with things like non-molestation orders, um, occupation orders, where there is some form of abuse taking place and you want the court to grant an order to prevent that person from continuing in that, should I say, behavior. And we also deal with dispute resolutions. And so there are those that will come to us in regards to civil matters that they have, where somebody has obviously paid for a service and they have not received the service that they paid for, and so they want to bring a claim in regards to all of that. So yes, we deal with different areas, and not just what I spoke about. And so yes, if you do need any legal assistance and you feel that we are capable of dealing with your matter, please take down the details that I'm about to give, and then you can either call us or contact us, and then we can help you in whichever circumstance that you have found yourself in. So in regards to our address, we are located in London. We are on the 4th floor of Anna House, 214 to 218 Tottenham High Road, and it's London, and the postcode is N154NP. So it's N154NP. Our offices are opened from Monday to Friday from 9:30 a.m. to 6 p.m. Our telephone number is 0208 493 7340. So it's 0208 493 7340. And if you would like to contact myself after the program or outside of our office hours, my telephone number is 075 35 81 3910. So it's 075 35 81 3910.
Thank you very much, Lawyer Eunice. So, ladies and gentlemen, all too soon our time is up. We've come to the end of this very wonderful program. I hope you have been impacted. If you join us at the latter part of this program, of course, we have a recorded version on YouTube. You can go there and watch from the beginning. And if you feel there's anything that you are not clear with, Lawyer Eunice has left her contact details and her phone number. Feel free to call her, and she'll be very happy to be of assistance to you. So we'd just like to say goodbye. Take good care of yourselves, and we'll hopefully see you very soon. Thank you, and have a good day. Bye-bye.
Thank you so much. Bye.
Bye.
Based in London, we are a dynamic award-winning firm specializing in a range of legal services, including family law, matrimonial law, immigration, dispute resolution, Ghanaian customary and family law. At BWF, our solicitors are pleased to offer high-quality legal representation at competitive rates. Our senior partner, Bernard Owusu, has over 29 years' experience as a lawyer in the UK. BWF solicitors provide independent and practical legal assistance for all kinds of family matters, such as childcare, contested and uncontested divorce, and injunctions for domestic violence. Our childcare and family team appreciate the issues facing you in this difficult time, which is why we offer confidential advice delivered in a sensitive manner. Our senior partner is an accredited member of the Law Society Family Law Accreditation Panel, which guarantees expert representation in all family and matrimonial cases. Are you seeking advice on immigration-related matters? At BWF Solicitors, our immigration team are experts in dealing with everything from general immigration to complex immigration work permits, arranging student visas, as well as entry clearance visas, family visas, and appeals. Our senior partner is an accredited member of the Law Society Immigration Accreditation Panel, which guarantees expert representation. Our office is open from 9:30 a.m. to 6 p.m. Monday to Friday, and on Saturdays by appointment only from 10 a.m. to 4 p.m. We are located at 4th floor Anna House, 214 to 218 Tottenham High Road, London, N15 4NP, just a short walk from Seven Sisters Underground. Our senior partner, Bernardo Wusu, is also a qualified barrister and a member of the Ghana Bar Association. He has acted as an expert in court cases involving aspects of Ghanaian law. He has also advised local authorities, the official solicitor's office, and other solicitors on the intricacies of Ghanaian law, and is a regular contributor on the radio and TV on matters concerning Ghanaian law.